Hi, I'm Nathan Whitbread, and this is video 3 in my series on the top 10 questions I get asked by HR leaders. So here we go. Number 3, what are reasonable adjustments? Well, it's a much used term and it relates to the Equality Act. Now, the Equality Act is relevant to you if you have a disability. So, for example, if you're someone who has a mental or physical disability that has a substantial adverse impact on your ability to carry out your day-to-day normal activities, and it must last at least 12 months. Now, do you need to have a diagnosis? Arguably not. You just need to demonstrate you've got the disability. But the linchpin of this bit of law is all around reasonable adjustments. And they're defined as something that removes a substantial disadvantage that you have compared with your abled colleagues. So what is reasonable? Well, the reasonableness comes under 3 areas. It must be something that removes an obstacle, it must be practical, and it must be cost effective based on the organisation. Now, that's something that has to be negotiated, but arguably, once it's been defined as reasonable, the organisation then has a legal responsibility to implement it. I would argue as well that it's worth considering reviewing it regularly, because as our organisations change, we need to review the adjustments to make sure they're still useful and relevant.